evidence that it needs to render a fair verdict. Don't surrender to the president's stonewalling. It will allow the president to be above the law and deprive the American people of truth in the process. A fair trial is essential in every way. Important for the president, who hopes to be exonerated, not merely acquitted by a trial seen as unfair. Important for the Senate, whose vital role is to continue to protect and defend the Constitution of the United States, which has preserved our American liberty for centuries. And finally, important for the American people, who expect a quest for truth, fairness, and justice. History is watching, and the House managers urge that you support the amendment, and I reserve the balance of my time.
Thank you, Counsel. Mr. Cipollone.
Mr. Chief Justice, Patrick Philbin will present our opposition.
Very well. Mr. Philbin.
Thank you, Mr. Chief Justice, Majority Leader McConnell, Democratic Leader Schumer, Senators. It's remarkable that after taking the action of the breathtaking gravity of voting to impeach the duly elected President of the United States, and after saying for weeks that they had overwhelming evidence to support their case, the first thing that the House managers have done upon arriving finally in this chamber after waiting for 33 days is to say, well, actually, we need more evidence. We're not ready to present our case. We need to have subpoenas and we need to do more discovery because we don't have the evidence we need to support our case. This is stunning. It's a stunning admission of the inadequate and broken process that the House Democrats ran in this impeachment inquiry that failed to compile a record to support their charges. It's stunning that they don't have the evidence they need to present their case and that they don't really have a case. If a litigant showed up in any court in this country on the day of trial and said to the judge, actually, Your Honor, we're not ready to go. We need more discovery. We need to do some more subpoenas. We need to do some more work. They'd be thrown out of court and the lawyers would probably be sanctioned. This is not the sort of proceeding that this body should condone. Now, we've just heard that this is so important. Let's consider what's really at issue in the resolution here and the amendment. It's a matter of timing. It's a matter of when this body will consider whether there should be witnesses or subpoenas for documents. Why is it that the managers, the House managers, are so afraid to have to present their case, remember, they've had weeks of a process that they entirely controlled. They had 17 witnesses who testified first in secret and then in public. They've compiled a record with thousands of pages of reports, and they're apparently afraid to just make a presentation based on the record that they compiled and then have you decide whether there's any there, whether there's anything worth trying to talk to more witnesses about. Why is it that they can't wait a few days to make their presentation on everything they've been preparing for weeks and then have that issue considered? Because they don't think that there is any there, and they want to ram this through now. And they want to ram this through now when it's something that they themselves failed to do. So I want to unpack a couple of the aspects of what they're asking this body to do. Part of it relates to the broken process in the House and how that process was inadequate and invalid and compiled an inadequate record. And part of it has to do with what accepting their request to have this body do their job for them would do to this institution going forward, and how it would alter forever the relationship between the House and the Senate in impeachment proceedings. So first, as to the process in the House. What they're asking, the House manager asking this body to do now is really to do their job for them, because they didn't take the measures to pursue these documents in the House proceedings. And there have been a number of statements made about They tried to get the documents, and no executive privilege was asserted and things like that. Let's look at what actually happened. They issued a subpoena to the White House. And the White House explained, and we were told a few minutes ago, that the White House provided no response, it provided no rationale. That's not true. In a letter of October 18th, White House counsel Pat Cipollone explained in 3 pages of legal argument why that subpoena was invalid. And that subpoena was invalid because it was issued without authorization. We've heard a lot today about how the Constitution assigns the sole power of impeachment to the House. That's right. That's what Article 1, Section 2 says. It assigns the sole power of impeachment to the House, not to any member of the House. And no committee of the House can exercise that authority to issue subpoenas until it's been delegated that authority by a vote of the House. There was no vote from the House. Instead, Speaker Pelosi held a press conference, and she purported by holding a press conference on September 24th to delegate the authority of the House to Manager Schiff and several other committees and have them issue subpoenas. All of those subpoenas were invalid. And that was explained to the House, to Manager Schiff and the other chairman of those committees at the time in that October 18th letter. Did the House take any steps to remedy that? Did they try to dispute that? Did they go to court? Did they do anything to resolve that problem? No. Because as we know, all that they wanted to do was issue a subpoena and move on. They just wanted to get through the impeachment process as quick as possible and get it done before Christmas. That was their goal. So those subpoenas were unauthorized. Now, what about some of the other things that they brought up? The witnesses. Witnesses who were directed not to testify. And part on this, we've heard Manager Schiff say several times that the White House never asserted executive privilege. Well, let me be clear on that. That's a lawyer's trick, because it is technically true that the White House didn't assert executive privilege, because there's a particular situation in which you do that and a particular way that you do that. But there's another doctrine of immunity of senior advisors to the president that is based on the same principles as executive privilege, and that has been asserted by presidents of both political parties since the 1970s at least. So that's, and this is what one attorney general explained about that. Quote, "The immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests." End quote. That was Attorney General Janet Reno in the Clinton administration, explaining that senior advisors to the president are immune from congressional compulsion. And that doctrine, that immunity, is rooted in the same principles of executive privilege. It's been asserted by all presidents since the 1970s, and that was the basis on which a number of the advisors whose pictures they put up were directed not to testify. Did they try to challenge that in court? Did they go to court on that one? Did they try to go through the constitutionally mandated accommodations process to see if there was a way to come up with some aspect of testimony that could be provided? No, none of that. They just wanted to forge ahead, rush through the process, not have the evidence, and then use that as another charge in their charging sheet for the impeachment, calling it obstruction of Congress. And what that is Professor Turley explained, this idea that when there's a conflict between the executive branch and the House and seeking information, and the president is asserting constitutionally based privileges, that's part of the operation of separation of powers. That is the president's constitutional duty to defend the prerogatives of the office for the future occupants of that office. And it is not something that can be charged as an impeachable offense, as the House Democrats have tried to say here. To do that is an abuse of power. That's what Professor Turley explained. It's Congress's, it's the House Democrats' abuse of power. We just heard Manager Lofgren refer to executive privilege as a distraction. She was asserting that these issues of executive privilege are just a distraction that shouldn't hold things up. But this is what the Supreme Court has said about executive privilege in Nixon versus the United States, that the protections for confidentiality and executive privilege are, quote, fundamental to the operations of government and inextricably rooted in the separation of powers under the Constitution, end quote. Inextricably rooted in the separation of powers. That's why it's the president's duty to defend executive branch confidentiality interests, and that is what the president was doing here. Now, the process that they pursued in the House abandoned any effort beyond issuing the first subpoena that was invalid to work out an accommodation with the White House, and instead just tried to rush ahead to have the impeachment done by Christmas. What does that lead to now? They're coming to this body after a process that was half-baked, that didn't compile a record sufficient to support their charges, and asking this body to do their job for them. Now, as Leader McConnell pointed out in some comments earlier today, to allow that, to accept the idea that the House can bring an impeachment here that is not adequately supported, that has not been investigated, that has not got a record to support it, and to turn this body into the investigatory body would permanently alter the relationship between the House and the Senate in impeachment proceedings. It's not the role of the Senate to have to do the House's job for them. It's not the role of the Senate to be doing an investigation and to be doing discovery in a matter like the impeachment of a president of the United States. If the House has not done the investigation and cannot support its case, it's not the time once it arrives here to start doing all that work. That's something that's the House's role. So, this is something that is important for this institution, I believe, not to allow the House to turn it into a situation where this body would have to be doing the House's work for it. If there is not evidence to support the case, if they haven't done their investigation, then they're not going to be able to support their case. Again, what's at issue here, and I think it's important to recall on the issue of this amendment, it's not whether the Senate, whether the body will be considering whether there should be witnesses or not, but when that should be considered. And there is no reason not to take the approach that was done in the Clinton impeachment. 100 senators agreed then that it made sense to hear from both sides before making a determination on that, to hear from both sides, to see what sort of case the House could present and the president's defense. And that makes sense. In every trial system, there is a mechanism for determining whether the parties have actually presented a triable issue, whether there is really some there that requires the further proceedings. And this body should take that common sense approach and hear what it is that the House managers have to say. Why are they afraid to present their case? They had weeks in a process that they controlled to compile their record, and they should be able to make that presentation now. And the one point that I will close on, we've heard Manager Schiff say several times that we have to have a fair process here, and I was struck by it that at one point he said if you allow only one side to present evidence, the outcome will be predetermined. The outcome will be predetermined. That's exactly what happened in the House. Let's recall that the process they had in the House was one-sided. They locked the president and his lawyers out. There was no due process for the president. They started with secret hearings in the basement. The president couldn't be present by his counsel. He couldn't present evidence. He couldn't cross-examine witnesses. And then there was a second round in public, where again they locked the president out. And we've heard, they just said that the president had an opportunity to participate. In the third round of hearings that they held before the Judiciary Committee, After one hearing on December 4th, Speaker Pelosi, on the morning of December 5th, went out and announced the conclusion of the Judiciary Committee proceedings. She announced that she was directing Chairman Nadler to draft articles of impeachment. That was before the day that they had set for the president even to tell them what rights he wanted to have and to exercise in their proceedings. It was all already predetermined. The outcome had been predetermined. The Judiciary Committee had already decided it was not going to have any fact hearings. There was no process for the president. He was never allowed to participate. So when Chairman Schiff says here that if you only allow one side to present evidence, that predetermines the outcome, that's what they did in the House, because they had a predetermined outcome there, because it was all one-sided. And for him to lecture this body now on what a fair process would be takes some gall. A fair process would be when you come to the day of trial, be ready to start the trial and present your case, not ask for more discovery. The president is ready to proceed, and the House manager should be ready to proceed, and this amendment should be rejected. Thank you.
Counsel, the House managers have 8 minutes remaining.
The House is certainly not asking the Senate to do the House's job. We're asking the Senate to do its job, to hold a trial. Have you ever heard of a trial that doesn't have evidence, that doesn't have witnesses? That's what this amendment is all about. Just a moment about the subpoenas. President Trump, refused to provide any information to the House, ordered all of his people to stonewall us. Now, it's been suggested that we should spend 2 or 3 years litigating that question. I was a young law student, actually, working on the Nixon impeachment many years ago. And I remember the day that the Supreme Court issued its unanimous decision that the president had to release the tapes. I think U.S. v. Nixon still governs the president. The House and the Senate should not be required to litigate U.S. v. Nixon back to the Supreme Court and down again for it to be good law. It is good law. The president has not complied with those requirements to the detriment of the truth. This isn't about helping the House. This isn't about helping the Senate. This is about getting to the truth and making sure that impartial justice is done and that the American people are satisfied that a fair trial has been held. I would yield now to my colleague, Mr. Schiff.
Mr. Philbin says that the House is not ready to present its case. Of course, that's not something you heard from any of the managers. We are ready. The House calls John Bolton. The House calls John Bolton. The House calls Mick Mulvaney. Let's get this trial started, shall we? We are ready to present our case. We are ready to call our witnesses. The question is, will you let us? That is the question before us. Now, Mr. Philbin says, well, if I showed up in court and said I wasn't ready, the judge would throw me out of the court. Of course, we're not saying we're not ready. But you know what happened if Mr. Philbin went into a court and the judge said, I've made a deal with the defendant. I'm not going to let the prosecutor call any witnesses. I'm not going to let the prosecutor present any documents. You know who'd get thrown out of the court? The judge. The judge would be taken out in handcuffs. So let's step out of this body for a moment and imagine what a real trial would look like. It would begin with the government receiving documents, being able to introduce documents, being able to call witnesses. This trial should be no different. Now, Mr. Philbin makes reference to the Cipollone letter on October 18th, which followed a Cipollone 8-page letter on October 8th saying, we're not going to do anything you ask. Part law, part diatribe, mostly diatribe. You should read it. It's a letter basically that says what the president said on that TV screen, which is, we're going to fight all subpoenas. The doctrine of absolute immunity that counsel refers to has, yes, it has been invoked or at least attempted by presidents of both parties and rejected uniformly by the courts. including in the most recent decision involving Don McGahn, the president's former White House counsel, where the court said that would make him a king. He's no king. And this trial has determined that he shall not become a king, accountable to no one, answerable to no one. And what's more, this idea of absolute immunity, this fever dream of presidents of both parties, it has no application to documents. Again, this amendment is on documents. There's no absolute immunity from providing documents. And as Representative Lofgren illustrated, when this case has gone to the Supreme Court, in the Nixon case, the court held that the interest in confidentiality in an impeachment proceeding must give way to the interests of the truth and the Senate and the American people. You cannot invoke privilege to protect wrongdoing. You cannot invoke privilege to protect evidence of a constitutional crime like we have here. And finally, with respect to those secret hearings that counsel keeps referring to, those secret depositions in the House were so secret that only 100 members of Congress were able to be there and participate. Only 100. That's how secret that chamber was. Imagine that in the grand jury proceedings in the Clinton investigation or in the Jaworski, the Nixon investigation, imagine inviting 50 or 100 members of Congress to sit in on those. Imagine, as the president would like here, apparently the president insisting on having his lawyer in the grand jury because there was a case being investigated against him. Now, we had no grand jury here. Why is that? Why did we have no grand jury here? Why was there no special prosecutor here? Because the Justice Department said they're not going to look into this. Bill Barr's Justice Department said there's nothing to see here. If it were up to that Justice Department, you wouldn't know anything about this. That's why there was no grand jury. That's why we in the House had to do the investigative work ourselves. And yes, just like in the Nixon case, just like in the Clinton case, we used depositions. And you know what deposition rules we used? Those terribly unfair deposition rules we used? They were written by the Republicans. We used the same rules that the GOP House members used. That's how terribly unfair they were. My gosh, they used our rules. How dare they? How dare they? And now why did we do depositions? Because we didn't want one witness to hear what another witness was saying so they could either tailor their stories or know that they just had to admit so much and no more. It's how every credible investigation works. And this, you know, the counsel can repeat all they like that the president didn't have a chance to participate, didn't have a chance to have counsel present in the Judiciary Committee or to offer evidence. They can say as much as they like. It doesn't make it any more true when they make the same false representation time and time again. It just makes it that much more deliberate and onerous. The president could have presented evidence in the Judiciary Committee. He chose not to. And there's a reason for that. There's a reason why the witnesses they've talked about aren't material witnesses. They don't go to the question of whether the president withheld the aid for this corrupt purpose. They don't go to any of that because they have no witnesses to absolve the president on the facts. You should want to see these documents. You should want to see them. You should want to know what these private emails and text messages have to say. If you're going to make a decision about the president's guilt or innocence, if you're going to make a decision about whether he should be removed from office, you should want to see what these documents say. Now, if you don't care, if you've made up your mind that he's the president of my party or for whatever reason, I'm not interested. And what's more, I don't really want the country to see this. Well, that's a wholly different matter. But that's not what your oath requires. It's not what your oath requires. The oath requires you to do impartial justice, which means to see the evidence. To see the evidence. That's all we're asking. Just don't blind yourself to the evidence. It's just I yield back.
Thank you. The majority leader is recognized.
I send a motion to the desk to table the amendment and ask for the ayes and nays.
The question is on the motion to table. Is there sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. Mr. Burr. Aye. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins.
All right, this
Mr.
is another
Coons.
test of Mitch McConnell's read on the
Cornyn.
Senate majority as they vote on the question of whether to table the amendment that's been argued
Mr.
for the last couple of hours by Chuck Schumer that would essentially call for the release of
Mr.
documents,
Crapo.
some evidence. And Mitch McConnell, as he said he would, now has put forward the motion to table it. So
Daines.
the yes votes you're hearing are to table
Ms. Duckworth.
this amendment. Let's continue to listen to the vote.
Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen? No. Mr. Warner? No. Ms. Warren?
No.
Mr. Whitehouse? No. Mr. Wicker? Mr. Wyden? No. Mr. Young?
So we're waiting for the final vote here. Again, this was a vote to table or spike, whatever you want to call it, the Schumer
Are there any
amendment.
senators in the chamber wishing to vote or change his or her vote? If not, the yeas are 53, the nays are 47. The amendment is tabled. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain documents and records from the State Department, and I ask that it be read.
The clerk will read the amendment.
The senator from New York, Mr. Schumer, proposes an amendment, number 1285. At the appropriate place in the resolving clause, insert the following section. Notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedures and Practice in the Senate when sitting in impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the Secretary of Senate commanding him to produce, for the time period from January 1, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the Department of State, referring or relating to A, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21 and July 25, 2019 telephone calls, as well as the President's September 25, 2019 meeting with the President of Ukraine in New York. B, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF, including but not limited to all communications with the White House, Department of Defense, and the Office of Management and Budget, as well as the Ukrainian government's knowledge prior to August 28, 2019, of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance to Ukraine, including all meetings, calls, or other engagements with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine. C, all documents, communications, notes, and other records created or received by Secretary Michael R. Pompeo, Counselor T. Ulrich Breckbull, former Special Representative for Ukraine Negotiations Ambassador Kurt Volker, Deputy Assistant Secretary George Kent, then United States Embassy in Ukraine Chargé d'Affaires William B. Taylor, and Ambassador to the European Union Gordon Sondland, and other State Department officials relating to efforts to 1, solicit, request, demand, induce, persuade, or coerce Ukraine to conduct or announce investigations. 2, schedule, cancel, or withhold a White House meeting for Ukraine's president, Or 3, hold and then release military and other security assistance to Ukraine. D, any meetings or proposed meetings at or involving the White House that relate to Ukraine, including but not limited to 1, President Zelensky's inauguration on May 20, 2019 in Kiev, Ukraine, including but not limited to President Trump's decision not to attend, to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and the subsequent decision about the composition of the delegation of the United States. 2, a meeting at the White House on or around May 23, 2019, involving, among others, President Trump, then Special Representative for Ukraine negotiations, Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union, Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3, meetings at the White House on or about July 10, 2019, involving Ukrainian officials Andriy Yermak and Alexander Danieluk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, and Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and a subsequent meeting in the wardroom. 4, a meeting at the White House on or around August 30, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper. 5, a planned meeting, later canceled in Warsaw, Poland, on or around September 1, 2019, between President Trump and President Zelensky, and subsequently attended by Vice President Pence. And 6, a meeting at the White House on or around September 11, 2019, involving President Trump, Vice President Pence, and Mr. Mulvaney concerning the lifting of the hold on security assistance for Ukraine. E, all communications, including but not limited to WhatsApp or text messages on private devices between current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, Ambassador Sondland, Ambassador Taylor, and Deputy Assistant Secretary Kent, and the following: President Zelensky, Andriy Yermak, or individuals or entities associated with or acting in any capacity as a representative, agent, or proxy for President Zelensky before and after his election. F, all records specifically identified by witnesses in the House of Representatives impeachment inquiry that memorialize key events or concerns, and any records reflecting an official response thereto, including but not limited to 1, on August 29, 2019 cable sent by Ambassador Taylor to Secretary Pompeo. 2, an August 16, 2019 memorandum to file written by Deputy Assistant Secretary Kent. And 3, a September 15, 2019 memorandum to file written by Deputy Assistant Secretary Kent. G, all meetings or calls, including but not limited to all requests for or records of meetings or telephone calls, scheduling items, calendar entries, State Department visitor records, and email or text messages using personal or work-related devices between or among 1, current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, and Ambassador Sondland, and 2, Rudolph W. Giuliani, Victoria Tensing, or Joseph DeGeneva, and H, the curtailment or recall of former United States Ambassador to Ukraine, Marie Masha Yovanovitch, for the United States Embassy in Kiev, including credible threat reports against her and any protective security measures taken in response. And 2, the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice.
The Majority Leader is recognized.
I now ask for a brief 10-minute recess before the parties are recognized to debate the Schumer amendment. At the end of the debate time, I'll again move to table the amendment as the timing of these votes are specified in the underlying resolution. So I ask consent that the Senate stand in recess subject to the call of the chair.
Without objection, the Senate is in recess.
So Majority Leader McConnell essentially saying that he will abide by this notion in the rules of dealing with issues of documents and witnesses after the days of arguments today. But it's been an important day as Chuck Schumer, as he promised he would bring forth a number of proposed amendments. This particular one, the second one in a row, specifically asking for documents. This one geared more towards State Department documents, things that they say they have been deprived of. Back here with Chuck Todd and Andrea Mitchell and Carol Lamb. Weigh in where we are right now, Chuck.
Well, look, I think when you look at sort of where we are today, I think it is worth noting that while we're arguing about how to put the trial together, it is interesting how the two sides have handled today. The Democrats, led by Adam Schiff, have decided to make their process arguments through the lens of the larger issue that they're trying to prosecute. They're prosecuting their case. They're making their case. Olofgren did the same thing when she was up there. The president's attorneys are clearly responding to the issue at the moment. That's fine, but it is a lack of awareness of the larger audience out there. Now, will this matter in the grand scheme of things? Maybe it doesn't. Maybe it won't long term. But I think today it feels like an uneven process here. It feels like the Democrats have more of a plan on how to manage today than Trump's legal team did. That's just, again, we know they each had a plan, but I just think from just purely presentation standpoint on that front too, I mean, it's clear the managers said, a lot of people are tuning in today, don't treat this like a process debate, and they haven't.
And that this is a political trial. An impeachment trial is not a court of law. It is a court in the Senate. And so they are appealing not only to the political instincts and to the experience of the senators, who are all elected officials, many of them lawyers, but also to the larger public. And they are making the case, the argument, as Chuck just said, about what they claim the president did that deserves impeachment from their standpoint, and making and framing their demand for documents in that context of we need this proof. And he, as one of the articles, of course, is obstruction of Congress. He has refused our subpoenas. They can't make the argument that they didn't subpoena these documents as they are making that they didn't subpoena the witnesses like John Bolton, because in this case they did try to get these documents and were rejected at every turn.
But Mitch McConnell essentially saying, wait, there will be an opportunity potentially for this.
Well, it's a tougher opportunity down the road. Yeah. There are a lot of trapdoors built embodied in this resolution. I would suspect that the response will be the party line response, which was a 53 to 47 clean party line vote to table, which is to kill it.
He's holding his majority together.
But it also means he has made a real promise on this witness vote to those folks, or they wouldn't be sticking by him. All right, when I say those folks, meaning a Murkowski, a Collins, or Mitt Romney, the three that we know are much more open to witnesses and whatever. It is just by his actions, the fact that he sort of caved on these little maneuvers about giving more time. I think it's clear he doesn't have control of 51 votes whenever he wants it. He only has it under certain circumstances.
And you could argue, and Carol would have more expertise certainly than the non-lawyers on this panel, that having the documents in front of you, in front of the senators, when they hear the opening arguments to come, would be very helpful to the Democrats who are trying to make this case.
And beyond that, I mean, I've been on a jury before. The lawyers come up and tell you what they're going to tell you and who they're going to put on for you. In this case, they can't make that promise.
Right. Well, they can't make that promise, but you know, these what the Democrats are really saying is that the White House did not engage in a good faith attempt in any form to comply with these document subpoenas during the House investigation. And so they're doing it again now in the Senate, and they have to set up this dialogue. But by tabling the vote on this amendment, Mitch McConnell is creating a very interesting situation, because let's say as things progress, it becomes exceedingly clear that some documents should be produced. Well, you don't just push a button and produce these documents. You know, there's a lot of work that goes into finding these documents, reviewing them, determining whether some should be withheld for privilege or redacted for privilege. And so we're really kind of kicking the can down the road, and I think they're going to have to keep a real eye on what the temperature of the Republicans is like. Yeah.
There's a reason they want to kick the can down the road. Because if you kick it down the road and you have this vote in, say, 10 days, well, then all of a sudden, boy, we're in the middle. The Iowa caucuses start tomorrow. The presidential campaign is here. the more you kick this into 2020, the easier it will be for McConnell to argue, let the voters decide, let the voters decide.
Exactly.
And even those senators that are uncomfortable with this strategy can be wooed on the, well, boy, the calendar is the calendar.
Oh.
This is a strategy by the majority leader in order to make this decision later in the calendar.
Let me get out to Casey Hunt at the Capitol. Casey, what do you have?
Well, Lester, I've been talking to sources about how this all unfolded today, these last-minute kind of maneuvers and changes to how we're going to see this trial unfold. And I think the earlier point that Chuck was making is the right one. I think that there was not necessarily a focus among Senate Republicans on some of these issues that turned out to become problems for them. These questions about making arguments in the middle of the night because of these long 12-hour, 2-day arguments that originally were in the plan. This idea that the evidence was going to be squashed from the outset. Essentially, moderate Republicans were so focused on the witness issue that to a certain extent, some of these other issues kind of passed them by. And it's clear from how McConnell reacted that he does, in fact, have a very delicate balancing act going on inside his own conference. And he really didn't want to lose a single Republican vote here on the floor in this initial opening bid. It was really about keeping all of these Republicans together. And while it's important, you know, for him to be seen not angering the president, for him to be working with the White House for, you know, his own political reasons, at the end of the day, keeping control of this process is more important to him, and this is what was required. And, you know, I do think that that shows you that there still is an element of unpredictability in this process. You know, sources that I've been talking to today said, well, you know, you're asking me to predict how this witness vote's going to go. I couldn't have predicted that what unfolded today on the Senate floor was actually going to happen if you had asked me about it just, you know, a few hours ago. So, you know, I think it's important to underscore that this is still a very fluid, very high stakes thing, even though, you know, to a certain extent our politics feel preordained. Lester.
Yeah, we are on a short break, which, as we know, those concerned to lengthier breaks, but it gives us a chance to kind of explore what we're seeing and what the reaction has been. And in fact, that brings me now to Hallie Jackson at the White House. What's the word from there?
So a couple of things here, Lester, on the conversation that you're having. The element of unpredictability, as Casey puts it, is looming over this entire trial. I can tell you that the president's legal team, according to sources close to it, had been preparing for a process and procedural argument and discussion today. What you saw from House Democrats, as Chuck notes, and the managers there, was more of a substantive argument. Now, the defense attorneys, I'm told, and they alluded to this publicly, are ready to talk about what they've described as irregularities in the House impeachment process and so on when they deliver their opening arguments, but that is not going to happen for several more days. And remember who they are playing to. Somebody, not the 100 senators necessarily sitting in the Senate floor right now, but the man sitting in a hotel suite in Switzerland, and that is President Trump, who wants to see a full-throated and vociferous defense from his allies here, from the people who are tasked with doing that. I think that there are some attorneys representing the president who may have delivered on that, some who may have been sort of more tasked with laying out some of the factual pieces of the procedural case. But I will say that President Trump is clearly engaged in this. Congressman Mark Meadows is one of his closest allies over on Capitol Hill. He is also a member of the broader impeachment team, somebody who will be doing some messaging here. He told one of our producers on Capitol Hill that the president is getting minute-by-minute updates on what is happening in this impeachment trial. And I can tell you that while it is late night in Switzerland right now, the president will be up early. He will be giving an interview, we've confirmed, with administration officials to one of the outlets that he talks to frequently, Fox Business. And that'll be our real first opportunity to hear from the president on camera about how he thinks today went and what he expects to see moving forward. Again, cannot say this enough. The White House wants this wrapped up. Currently, present tense, they want this to get done as quickly as possible. The resolution changes that have happened here mean that that is not going to be as quick as they thought. But here's the thing. That's also not necessarily, based on my sense in the reporting that I've had here, that's not the hill they want to die on, right? So that might be something that clearly they've been willing to sort of let go. Mitch McConnell has been willing to let go. Witnesses, that is a very different story, and that is where the rubber is going to meet the road once we get past these opening arguments, which right now look like they could stretch into the middle of next week.
Yeah, and we should know just a few minutes before, let's see, a few minutes before 11 o'clock at night right now in Davos, where the president is, so chances are he is up and paying attention to this. And I want to, Chuck, come back to something you said as we came into that break, and the difference in the styles. The Democratic managers coming out ready to essentially putting their case on.
They're ready to make their case.
And we heard the process argument from the president's lawyers. Do you think there's some second guessing on that right now?
I would imagine there is, but I also want to give the president's legal team a little bit of a cover in this one situation, which is the House managers are members of Congress. They debate for a living. They speak for a living. They do this. They're on the floor a lot. So it's possible that the three lawyers that have spoken on behalf of the president, this is new terrain for them. First time they've ever even remotely done something like this. So I think you have to give them some slack on that. I mean, Carol would, as a lawyer, would you give them a little slack? But look, that's the only explanation I could come up with beyond the substance here. I think they made a miscalculation. I think they did not, which is surprising because usually all the president thinks about is talking beyond
Carol, what about
folks
strategy?
in the room.
I just don't think it was a very effective approach for the president's defense team to say they want us to do their work for them now. They're not ready to go to trial. And I think Adam Schiff made absolutely the right response, which is we are absolutely ready to go. But in any trial, in a criminal trial, you can indict a case, you can start the trial, and if you hear something or find out new evidence, it's happened to me, you subpoena it during the trial. There's absolutely nothing wrong with that.
Well, Carol, we're in for the long haul here. This is just the beginning, but this is going to conclude this portion of our coverage of the Senate impeachment trial of President Trump. Some of you will be back with us shortly when the Senate returns momentarily from its recess, while the rest of you will return to regular programming. For all of us at NBC News, I'm Lester Holt in New York. I'll see you on Nightly News. Until then, good day.
Now on WYFF News 4 at 5.
It doesn't happen often.